Did you know that even if you already have your green card or have lived in the US for many years, you can still be deported because of a past immigration mistake? But here's something important to remember. Hope's not lost. This actually happened to one of our clients. Stick around because this situation is more common than you might think, and it might help you if you're going through something similar. Let's call our client Luis. He came to the US 7 years ago, fell in love with a US citizen, got married, and received a conditional residency, which is only valid for 2 years. As the expiration date approached, he and his wife filed Form I-751 to remove the conditions on his green card. But then something happened. USCIS began investigating his case. They called his wife for an interview, and that's where everything came apart. She admitted that their marriage wasn't real. They had only married to help each other out, that they lived apart and both were already with new partners. The result? His petition was denied and he was sent straight to immigration court for deportation. Let me be very clear. This video does not condone immigration fraud. We are not saying it's okay to lie. What we are saying is that every immigrant has the right to legal defense. Many mistakes out of fear, misinformation, or because they trusted the wrong person. Our job is to help you understand your rights and your legal options. So let's start by answering, what is immigration fraud and why is it a deportable offense? If someone gets a green card through a fake marriage, the government considers them inadmissible due to fraud or willful misrepresentation of a material fact. Put simply, they lied or hid important information to get an immigration benefit. Under the law, this is grounds for having your green card taken away and being deported. But that's not the end of the story. This is where a little known waiver might come into play. What is the 237A1H fraud waiver? It allows someone to keep their green card even if it was obtained through fraud or misrepresentation. But there are some key conditions you have to meet. 1. You must have a qualifying relative in the US. This can be a child, a parent, mother, father who is a US citizen or green card holder. The spouse from the fraudulent marriage does not count. 2. You must have entered the US lawfully. For example, if you entered with a valid visa, even if you later lied to get your green card, you may still be eligible. And 3. You must not have other grounds of inadmissibility. If besides the fraud you committed other serious crimes, the judge may deny your request. And here's something very important. You do not need to prove hardship or extreme difficulty to a family member. Unlike other waivers, the 237A1H waiver does not require you to prove your deportation would cause extreme hardship to a qualifying relative. However, even though it's not mandatory, showing hardship sure can help. This waiver is discretionary, meaning the judge decides based on your entire record. Showing that your child, parent, or other family member would suffer emotionally, medically, or financially if you were deported can make the judge view your case more sympathetically because it's not just about you anymore. Now here's something else you need to know. This waiver can only be requested in front of an immigration judge, meaning you have to be in removal. There is no special form and there is no government filing fee. Your attorney must notify the judge that you intend to apply for the waiver and submit the necessary evidence during the case. Now let's break it down. What evidence do you need to submit for a 237A1H waiver? So, birth certificate of a US citizen, a lawful permanent resident, child. You gotta prove they're a relative, and you have to prove their legal status, being citizen or lawful permanent resident. If it's a parent, proof of citizenship or residency, naturalization certificate or a green card. Tax history, stable employment records, community involvement, letters of support from family, friends, and employers, and hardship evidence such as medical records, psychological, psychiatric evaluations, financial documentation showing economic dependence. All of this helps build a picture that you deserve a second chance. In Luis's case, he had a 5-year-old US citizen son. He had never been in trouble with the law, he paid his taxes, and had stable employment. Even though the judge acknowledged the fraud, he also saw how much Luis had done right since then. After months of fighting, the judge granted, months normally. Now it's more like years. The judge granted the waiver, Luis kept his green card, and now he can apply for US citizenship. This case teaches us 2 powerful lessons. First, never lie during the immigration process, not to get a visa, not to adjust your status, and not during immigration interviews. Everything you say gets recorded, and if the government finds inconsistencies even years later, they can take away your papers or even deport you. Second, if you've already made a mistake, you can still fight back. There are legal waivers. There are ways to ask for a second chance, but you need to do things the right way. And it all starts with professional legal advice. Don't try to handle it on your own. Don't make legal decisions by yourself. And never sign any immigration documents without First, talking to an attorney. If you or someone you know is facing fraud charges or being accused of a sham marriage, talk to an immigration attorney and find out if this waiver might apply. Share this video. Someone out there may need this information and not even know where to start. And if you want us to keep breaking down real cases with clear, honest, no-nonsense information, just let us know below. Subscribe, hit the notification bell, and join Immigration Nation. See you in the next video, and remember, we're in this together.
Hey, did you like the video? I invite you to watch another video where I share more tips on how to protect your reputation as an immigrant. Until next time.